Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. And if not, I hope you're getting there. Every day is not a good day. I think the bad days help us appreciate the good days more. So, wherever you are, I wish you well. I am going to cover the closing arguments for Brian as promised. The last video was Brian's opening statement. If you haven't seen that, I recommend you watch it first, but you don't have to. This will still make sense either way. All right, so we're going to get into it rather quickly. I'm going to run the intro, thank the members, thank you for being here. I appreciate you. If you like the video, if you appreciate the content, please give it a thumbs up and, stick around, subscribe, hang out with us a while. It's a cool vibe over here, I promise. I'll see you on the other side of the intro. All right, let's get right into it, shall we? We've got Brian's closing arguments. They were to be submitted no later than September 2nd and no longer than 5 pages. And Josh has gotten it exactly to 5 pages. I just blanked on his last name. I mean, no disrespect by just calling him Josh. Martell. Mr. Martell has gotten it to 5 pages. All right. Petitioner's written closing argument. Petitioner Brian C. Boone, former husband, respectfully submits his closing argument in support of his petition to modify the parenting and support orders and in opposition to the respondent's request states as follows. Respondent's request is that she get all of her alimony, that the $4,000 that is being held in an escrow account for child support be given to Brian, but only if she can direct how it spends. And she's got a bunch of stuff for her visitation. Number 1, the evidence at trial and applicable law overwhelmingly support granting the relief Mr. Boone seeks for the benefit of the party's minor child. And remember, all of this is meant to be done in the best interest of the child. So that is going to be a recurring theme here. I doubt it will be in Sarah's closing argument, but she might surprise us. But overwhelmingly, it seems to be about what's in the best interest of Sarah, per Sarah. Okay, number 2, since the respondent's former wife incarceration in February 2020, Mr. Boone has single-handedly provided a loving, stable home for the child, covering all, emphasized in bold, financial, emotional, and logistical needs without any contribution from the former wife. In contrast, the former wife, now a convicted murderer serving life in prison without parole, he got right to it. Number 2, called her a murderer. She's not going to like that. But I mean, that is what she's been found by the state of Florida. Has been completely unable to care for or support the child, having had no overnight contact since her arrest in 2020. Number 3, at trial, the former wife stipulated that Mr. Boone could relocate the child to that place in Florida. However, she did not agree to Mr. Boone's proposed parenting plan that provided for sole parental responsibility for Mr. Boone. 1 monthly visit with the child and the former wife, and 1 weekly phone call between the former wife and the minor child. So that's right. She did not agree to that, which I think we discussed this before. I thought it was super generous of Brian, especially having been to a state prison, not as an inmate, but as a visitor myself, like to go once a month. Logically, logistically, it's difficult. Most families will go like on holidays to see their loved one in there. I don't know, I guess some young moms with children who want to see their kids may go, who want their kids to, be connected usually to the father, right? Will make those extra treks. But there is a financial toll it takes, not only in what you immediately have to pay, and I'm speaking from my own experience. My oldest brother is doing 2 life sentences in the feds. You like just think of the wear and tear on your tires, or you have to rent a car, the gas, it adds up. And so, and in court, to be fair, Brian was like, if it could average out to 12 a year, that would be ideal because they have different obligations, extracurricular activities, sports, games that they like to go to, etc. But she would not agree to this. So that's, why we're moving forward. Okay. Former wife has shown no genuine accountability or remorse for the actions that led to her incarceration, right? George made her do it, and she's going to be, her release is pending. The evidence demonstrated that she continues to deflect blame for her predicament rather than take responsibility. Amen. Every chance she gets, it's somebody else's fault. She's the victim. This lack of insight into her own wrongdoing heightens concerns about her judgment and fitness as a parent. As it should. I mean, the little boy might be run over by a car with her, like pre-incarceration, and somehow it wouldn't be her fault. Just her inability and inability to take accountability, lack of self-awareness, like,
ma'am, what planet? Hi, we're here on Earth. Where are you? Can you come back down here?
A parent who cannot acknowledge such a grave error. And I mean, she put it in writing. What did she say? That it was an obscure incident, not like the worst mistake of my life, which I'm deeply repentant for. None of that. Anyway, a homicide that left her imprisoned for life is ill-suited to make decisions affecting a child's well-being. Word. Like, I, to this day, believe she didn't understand that George was going to suffocate in there. I know some people think it was intentional. That one part, I think, was not intentional. She meant to leave him in there. I just don't think she had the mental capacity to understand that he legitimately couldn't breathe. That being in a confined space and being trapped in a position like that is deadly. Florida's public policy strongly condemns violent criminal behavior. Right, it's not good for society. A parent incarcerated for a heinous, intentional act.
She intentionally left him in there.
Cannot simultaneously fulfill the obligations or enjoy the benefits of an active parent. Benefit, not right. Or rights, benefits. Brian gets to reap all the benefits of being an active parent. In fact, Florida law recognizes that a parent's lengthy incarceration for a serious felony is so contrary to a child's welfare that it can justify termination of parental rights. See MSB, VRB, you guys get it. While Mr. Boone is not presently seeking to terminate the former wife's parental rights, again, very gracious of him, this principle underscores how profoundly the former wife's situation has undermined her role in the child's life. So he's not trying to terminate, but look at this citation. It is, he could lawfully request that, but he's being reasonable, Your Honor. She is not. He's being reasonable because he feels it's in the best interest of the child. Number 7, Florida law presumes that shared parental responsibility is ideal, but that presumption yields when shared decision-making would be detrimental to the child, right? It's always what's in the best interest of the child. Here, sole parental responsibility in the father is not only warranted, it is essentially compelled by the circumstances.
You heard her, Your Honor. She sounds crazy.
Do you think he wants to call her every time a decision needs to be made? And do you think she's going to agree or be amicable about anything? She's not demonstrated that she has that capability to date. Okay, 8. The former wife has been entirely absent from the child's life for over 5 years and will remain so for the remainder of his minority. I mean, actually, for the remainder of his life, but he's keeping it contained because after the son reaches majority, the court has no say on what he does or doesn't do or how much access she has to him. By virtue of her incarceration until life's end, that's right, she's coming out toes first. Tell it, Mr. Martell. She is unable to participate in day-to-day parenting or any meaningful decision making. Number 9, Mr. Boone has already been exercising sole responsibility in practice since 2020 out of necessity. So before you even had to step in, Your Honor, he did it because she was arrested. He has taken over as he should. He stepped up to the circumstances. Formalizing sole parental responsibility in the father is necessary to avoid any confusion or conflict in decision making going forward. So we need you to let her know, Your Honor, that he's in charge so she can knock it the fuck off with all of the harassment about not being included.
We need it in writing, Your Honor.
You know how she respects an order. You know how an order of the court is important to Sarah. Number 10, awarding Mr. Boone's sole parental responsibility will serve the child's best interest. The child is thriving under Mr. Boone's sole care, which provides stability, consistency, and, drum roll please, safety. She didn't provide safety to him even when she was free, right? She put him in dangerous situations. I mean, first of all, the drinking, all of which would be jeopardized by giving the incarcerated former wife any decision-making authority. And the safety is important too, because as we get more into the trial footage, you'll hear Brian say she did not want the son vaccinated for COVID. And he did it anyway. Even though she says she's not included, they had a conversation, but he obviously overrode her.
Because, girl, you're in jail at that time. Like, you don't know what's going on out here in the world. But thank you for your 2 cents.
Number 11, it is simply not feasible for Mr. Boone to consult with a prisoner serving life without parole on major decisions about the child's education, medical care, or general welfare, especially when the imprisoned parent will have no financial stake or personal time investment in the decision itself, right? She's no skin in the game, as they say. She's nothing to lose, so she can just be reckless. She wants to be the puppet master, telling Brian how to parent from her jail cell or prison cell, whatever they're called. Number 12, more importantly, it is not in the child's best interest to do so, right? Even if Brian wanted to simp for her, it's not good for the child. So it doesn't matter what Brian and Sarah want, really Sarah, because she's all about what she wants. It's about what's best for their son. The former wife's inability to accept responsibility for her crime raises serious concerns about her judgment, right? The cognitive dissonance is real. Like, she can't even admit that she did what she's accused of, what she's convicted of. The trial evidence showed that rather than expressing remorse or cooperating in the child's welfare, she has made unfounded, inflammatory accusations against Mr. Boone, right? She had no receipts. She had all the sass, just talking. And we know she's not a reliable narrator just based on what we saw right before his opening statement, which I suggest you watch if you haven't. Mr. Boone, for example, accusing him of parental alienation simply because he has protected the child from exposure to trauma. Such behavior reflects a mindset that is not conducive to healthy co-parenting or prioritizing the child's needs. Right. Like
every time I have to make a decision, I don't want to run it by crazy. We need to live our lives in real time, based in reality, grounded in facts, rooted in honesty.
13. Consistent with the above. It's the gaslighting too. Like she gaslights everybody. So imagine like the gaslighting she does with her son. Like, no, you don't, you just talk to him and tell him whatever it is you need to tell him about what happened in prison, ma'am. Don't ask him too many questions, but you don't need to be involved in that nan decision, not nan. Okay. Consistent with the above, Mr. Boone's proposed parenting plan should be approved as it is tailored to the child's best interests under these unique circumstances. Mr. Boone's plan is generous yet prudent. It permits the former wife to maintain a relationship with the child through supervised monthly visitation at her correctional facility and weekly telephone calls. This plan ensures the child can have some contact with his mother, preserving their bond to the degree possible.
I mean, she did kill somebody.
Without compromising the child's safety or welfare. That is going to send Sarah through the roof. Number 14, the former wife's durational alimony award should be terminated retroactive to the date that Mr. Boone filed his petition to modify in April of 2022 due to the substantial change in circumstances and the elimination of her need for support. What was the substantial change? Her incarceration, even though she repeated during the trial, my incarceration has nothing to do with this. Girl, that is the reason we are here. That was the change. 15. Here, the former wife has no legitimate financial need for alimony at this time. Her incarceration means that the state of Florida, at taxpayer expense, y'all Floridians, stand up for your rights, is providing all her essential needs, including housing, food, clothing, and medical care, right? She doesn't have rent. She doesn't have, she's not buying groceries. She's not out looking, like I said, for Vogue's fall collection.
Not that she was while she was free. Let's all be honest.
She pays no rent, no utilities, no grocery bills, no insurance. The primary living expenses that alimony is designed to cover have been entirely assumed by the prison system. She done found another sugar daddy, and that is the state of Florida and the taxpayers. Any minimal personal expenses she might have, such as commissary items or phone minutes, are negligible and certainly not expenses the former husband should be ordered to finance. And I'm going to say, especially because he has the son, you're taking money out of his household. It's implied here, but let's put it out there because we know the flying monkeys, or as Hear Me Out calls them, the idiots, listen to these, right? And so you guys are encouraging her to take money out of her son's household so that she can talk on the phone and get honey buns. Really? And you're okay with that, Nicole? You who claims to have a son, that's good. 16. In short, the entire premise underlying the original alimony award to assist the former wife's post-marital living expenses and transition to self-sufficiency have been upended, right? She is never going to be self-sufficient because she is in prison for life. So there's no transition that he needs to fund.
She's transitioned herself into having the state of Florida as her sugar daddy.
Put simply, the former wife's incarceration has extinguished any reasonable claim of need for alimony, and it would be inequitable in the extreme to force Mr. Boone to keep paying. Never mind that nutty tutu is asking for him to pay it over 18 3/4 years, right? Like, girl, he divorced you in 2018. You think he want to be bothered with you for the next 18 years? Your son is going to be of majority in 3.
Quit playing, ma'am.
18. Moreover, the former wife's incarceration and conviction amount to a substantial change in circumstances that was not contemplated at the time of the divorce, which the judge said that, right?
We didn't know people were going to be criming.
In 2018, how could we? 19. The former wife stipulated that Mr. Boone does not owe him child support since she was incarcerated. I think does not owe her would be correct. Josh was trying to get this in the mail, get this e-faxed or whatever they do, since she was incarcerated in February 2020. So she agreed to that. But I don't know if he's going to mention that she wants to decide how that money is spent, the $4,000. 20. However, Florida law does not automatically extinguish a parent's duty to support a child due to incarceration. See Wilkerson v. Wilkerson. A parent's duty to support exists as a result of parenthood and is not erased by a criminal conviction. So this is for Miss Sarah, right? Because she can't share time, but she still owes money. In other words, the former wife's 21. In other words, the former wife's incarceration did not terminate her obligation to contribute to the child support. It merely rendered her unable to do so. The unfortunate result is that Mr. Boone and the child have borne the full financial burden with zero assistance from the former wife. For over 5 years, the former wife has paid nothing, zip, zero, zilch, toward the child's needs. She has failed to exercise any visitation. 22. Mr. Boone testified that between Feb 2020 and April 2022, he provided the former wife with direct monetary support, averaging $600 per month, in addition to paying $240 per month for a mini storage unit on her behalf. Oh, I think I got that flip-flop. I thought the storage was 600, but that makes sense. Okay. 23. During the same period, the former wife had a child support obligation of $367 per month to Mr. Boone based on his exercise of 100% time sharing, an imputed income of $60,000 annually to him, and minimum wage imputed to her. So he's putting that in there so that the judge understands the calculation used to get to the 367. 24. Extrapolated from February 2020 through the child's age of majority in October 2028, a span of 104 months, that obligation totals $38,168 in child support owed by the former wife. Child support that she will never satisfy given her sentence in prison. 25. Even without giving Mr. Boone any credits, and assuming that Mr. Boone owed the former wife the maximum amount of $26,000 in alimony arrears from Feb 2020 through the filing of the petition to modify in April of 2022, the former wife's child support obligation alone more than offsets any such claim. Okay, so here we have the corrected number because on the record they agreed to 15,000, but again, she was arrested the 25th of February. The payment arrangement was such that alimony was due on the 1st. So he already paid for February in 2020. It would start from April, but listen, what you gonna do? Okay, 26. Oh, wait, did I read that? The former wife's child support obligation more than offsets any such claim, right? So she owes him more than he owes her. But like he said in the opening, the petitioner is willing to call it a wash. 26. This calculation does not even account for the substantial sums Mr. Boone actually paid her directly, the storage expenses he covered, or the more than $14,000 in attorney's fees he has incurred in protecting his child's best interests against the former wife's persistent obstruction. Say it loud for the people in the back. The former wife's persistent obstruction. Anything Brian says, she opposes it every single time. Accordingly, any claim by the former wife for arrearages must be denied, as the equities and evidence overwhelmingly establish that Mr. Boone owes her nothing. Did you hear that, Sarah? Not a damn thing. 27. For all the foregoing reasons, petitioner Brian Boone respectfully requests that this court A. grant his modification petition and deny the former wife's outstanding motions, B. award him sole parental responsibility, C. approve his amended parenting plan, D. terminate his alimony obligation in order that neither party owes the other any arrearages for unpaid support, E. order the immediate release of any clerk-held funds to Mr. Boone, F. deny all relief sought by the former wife, including claims for alimony, sanctions, contempt, or attorney's fees, since she ain't got no attorney. Okay, and then that's it, guys. That is it. I think he laid it out clearly. It was articulate. He had receipts. I suspect that is not what we'll see when we get Sarah's closing argument, because it's like she's going to put the emphasis on argument based on nothing. And I'm kind of torn. I feel like she'll want to get it in, but then I'm like, she's a procrastinator. Maybe she won't even file it. And maybe that might be better for her. Although I don't know how it could get any worse, but leave it to Sarah, when she hits rock bottom, that is not good enough. Then she's got to get a jackhammer out. So she might keep on digging. We will see. But what do you guys think? I think it's more than fair, everything he's asking for, reasonable. Yeah, he's got a lot going on and he's got a teenage son. And some of you guys have adult children. You guys know I have one adult child. Teenage years are difficult. I did have to co-parent, but there was definitely a lot of animus on her father's side, not specifically from him, but his family in general. And it made it difficult. It makes it difficult when one parent is bad-mouthing the other parent or one family is bad-mouthing the other parent. And it creates animus in the household, so her telling the child things like, tell your dad to buy it, when she has no financial sort of skin in the game, it makes it difficult. And right now his son needs him. They need to have a bond together. They need to get through this transitional period of adolescence together. I mean, of course, there'll be arguments. He'll be driving soon, in a couple of years. And it doesn't, her gaslighting and her animus toward the father is not helpful for anyone, but it feels good to her, right? It's her, she's getting her supply, her narcissistic supply. And I think Brian's doing the right thing. I'm glad that he's being generous. I feel like if it ever comes up as a question, he can tell the son, look, I did provide for her to be able to see you. I drove you. If it comes to that, because I think that's a difficult conversation to say, oh, I terminated your mom's rights because of it might cause resentment, right? And then eventually when, in 3 years, if he decides to talk to her, then she's going to turn that into ammo. So I feel like he is very vested in the best interest of the child, which I applaud him for, actually. I think he's a good dad, just based on what I've seen and heard and read. And likewise, I think she's a horrible mom. I think her son is a possession, a tool. It is what she uses to sort of, what is the word? I can't think of the word, but to go after Brian, right? I mean, you heard the attorney in the opening statement say he did this for the mother of his child. And so she kind of like holds his, I don't know what the expression is, holds his feet to the fire for that, maybe. Um, yeah. So he is a pawn in his mother's game. And I think Brian is taking out the teeth in that fight. My analogies are all over the place. Apologies, but you get what I'm saying. I think Brian has the child's best interest at heart. And I think the judge will see that. And then we'll see if Sarah sends in some wacky letter or if she has a moment of clarity and sends in something reasonable, you know. She can't humble herself, so I'm not expecting that. I know we've seen that in the past where it was like the flying monkeys came back and kind of humbled herself as we saw the progressive motion she was filing. I know Lana said they all got in her ear about you're not putting anything in about your child. It's all money, 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 right? And so I don't know if they'll even have time to get to her because it's got to be postmarked by next Tuesday, and she's a procrastinator. But we'll see, and I'll keep you posted. I'll definitely keep you posted. In the meantime, make sure your post notifications are turned on because I'm going to be dropping more trial footage. I've got her call log leading up to the trial of like her frenetic dialing of people and what's like as things are coming in, just because we know she has that pattern right before she'd be texting Lana and Christina, like, what's it saying? Have you checked the docket? What are the YouTubers saying? So, yeah, we'll take a look at that too. Let me know if there's anything else you want to see regarding the family case, and I'll do my best to get it to you. You guys get to dictate what we cover. So, I will talk to you in the comments. Toodles.